trust and estate practitioners, as well as a fully accredited member of the Association of Lifetime Lawyers, which used to be Solicitors for the Elderly. I also sit on their main board, as well as working with the Law Society's Wills and Equity Committee, which essentially is a very long-winded way of saying that I know a thing or two about this area of law. What I'd like to begin with is talking about the importance of having wills in place. And before we can really get into that, I think it's worth understanding what would happen if you do not have a will in place. I get asked this question all the time. Well, if I pass away, doesn't everything just pass to my spouse? Not necessarily. If you pass away without a will in place, then the intestacy rules will apply. The intestacy rules are a set of rules determined by the government that say what will happen to your estate if you pass away. If you only have a surviving spouse and you do not have any children, then you're quite right, everything will pass to your spouse. But it's quite normal for people these days to have a spouse that survives them, as well as children and potentially grandchildren. And if that's the case, then your spouse will receive the first £322,000 by way of a statutory legacy, and then they will receive 50% of everything else. The other 50% of everything else will pass equally between your children. Can we just, make sure that everybody's on mute, if that's okay? I'm getting a bit of feedback. If one of your children passes away, then their children, if they have any, your grandchildren will inherit their share. So as you can see, it's not quite as simple as everything simply passing to each other. The rules go in further detail. If you aren't survived by a spouse or children, generally it will go up to your parents, and if your parents are predeceased you, then it will come out to your siblings of whole blood. That means siblings that have both the same parents as you. If you don't have that, then it will pass to your siblings of half blood, which means that they only share one parent with you, and so on and so forth. If there isn't anybody under the list of rules of intestacy to inherit, then the estate actually will pass to the Crown. And I know that sounds like a really unlikely scenario for many people, but at the moment, the official solicitor is dealing with about 6,000 cases of estates that could potentially pass to the Crown. As well as understanding the intestacy rules, it's quite important to understand the tax rules surrounding inheritance tax as well, because this feeds into part of the reason why it's so important to prepare your will. If your assets pass to a lawful spouse, and what I mean by that is someone that you have married or are in a civil partnership with, it doesn't include the term sort of common law wife, which gets thrown around, or common law husband, that gets thrown around quite a lot. That doesn't actually have any legal bearing in any way whatsoever. So if you haven't entered a legally binding marriage or civil partnership, then you will not be treated as a lawful spouse. Anything passing to your lawful spouse is exempt from inheritance tax due to a spouse exemption. So beneficiaries that are exempt from inheritance tax include your lawful spouse, charities and political parties. Beneficiaries who are not exempt from inheritance tax include your children or grandchildren, your friends or other family members. Everybody has an allowance against inheritance tax, and this is known as the nil rate band allowance. And essentially, everyone at the moment is entitled to £325,000 that they can leave to non-exempt beneficiaries without paying any inheritance tax whatsoever. If you're leaving your estate to your spouse, then that allowance is not used on the first death, and so it can be transferred over to the surviving spouse, so that a total of £650,000 can be left to your non-exempt beneficiaries without paying any inheritance tax. Everything above and beyond this is taxed at 40%. So inheritance tax is a very heavy tax. And as part of the will writing process, we look at ways that we can mitigate that. In addition to the the ordinary nil rate band, there is a residence nil rate band. Now, this isn't an increase of the initial allowance, because the initial allowance is super flexible. It doesn't matter what property you have or who you leave it to, that allowance just applies. The residence nil rate band is a beast all of its own, and that it has a lot of caveats attached to it. And in simple terms, it means that you have to have an interest in a property that you leave to your lineal descendants, which include your children or grandchildren, your stepchildren, foster children, adopted children, etc. You have to have used that property as your main residence for more than simply a trivial period of time. And you can't leave it to those beneficiaries on any type of trust. It has to go to them outright. If you meet that criteria, then it's possible that you could receive an additional allowance of £175,000 each. So that takes the individual's allowance up to £500,000, or for couples up to £1 million. But you should also note that there's an additional caveat in that if your estate is worth over £2 million, for every £2 above that limit, the residence nil rate band is reduced by £1. So there's a tapering effect to that allowance. And just like the ordinary nil rate band, this can be transferred between spouses. Okay, so that's a lot of information. Don't worry, you can get a copy of the slides afterwards. So the impact of intestacy, where you've got an estate that is passing under the rules of intestacy to a surviving spouse and children, there are situations where it could give rise to inheritance tax charge that could have otherwise been avoided on the first death. And it can cause other problems. So if we've got an estate that includes a house worth around 1.5 million and about £50,000 in cash, then if the husband were to pass away, the wife would receive a statutory legacy of 322,000 and then 50% of the remainder, which works out to be about £614,000. The children split the remaining £614,000 subject to inheritance tax. So the amount passing to the children could exceed, well, in this instance, it does exceed the tax allowances, and therefore there may be inheritance tax to pay. In this circumstance, they should be able to claim the ordinary nil rate band and the residence nil rate band, which would mean that £114,000 approximately will be subject to tax at 40%. If after the payment of funeral costs, legal costs, everything else, that £50 cash has been eaten away, then we have to ask ourselves, where are we going to find those funds from the estate to pay the inheritance tax? It could mean that a charge needs to be put on the property. It could mean that the property has to be sold in order to facilitate this, which obviously is not an ideal situation for your surviving spouse. There are other situations as well in which the property might need to be sold. For example, if the children simply want to get their hands on their full inheritance and aren't happy to allow the surviving spouse to remain in the property. This might not be typical in sort of a traditional family setup, but we're seeing lots and lots of blended families these days where it becomes more and more likely that those children will put their own needs above that of any step parent. So the best way to avoid these situations and the intestacy rules is simply to prepare your will. That's the way around it. Having a valid will in place will mean that your estate passes by the terms of your will and not the intestacy rules. When you prepare your will, your advisor should discuss lots of different things with you for a variety of reasons. They'll need to test and demonstrate that you have the requisite mental capacity to write your will. They also should be talking to you about your assets and liabilities in detail. This is largely because some assets will pass outside of your estate for inheritance tax purposes. So, for example, you may have a death in service benefit or a life assurance policy or pension. Generally speaking, they will pass outside of your estate for inheritance tax purposes, which means that they will pass without inheritance tax being due on them. However, in order for that to happen, you do have to have up-to-date letters of wishes or nominations in place with those assets. Otherwise, they could default to your estate in the terms of your will, which means they will be taxable as part of your estate as well. So if we can avoid that and make sure you've got those up-to-date nominations in place, the better. There will also be some assets that may have relief from inheritance tax, for example, business property relief, that may apply, and they can talk you through that. They'll want to know about any medical conditions that you might have that may have an impact on your capacity or ability to progress the matter. They should also discuss with you your family circumstances in quite some detail, including previous relationships. What some people don't realise is that a former spouse, if they have not remarried since you split, they could fall under, or they do fall under, a class of beneficiary that could make a claim against your estate should you pass away. And so we need to be aware of these things so that we can properly advise you and we can put steps in place that will help reduce the likelihood of those claims being successful. They will also likely want to know information about your personal items or any pets and things like that that you may have. It may be that you have classic cars or antiques that we need to know and take care of. And they'll also ask you about whether you have any digital assets or other valuables as well. Using that information, they are then able to provide you with an overview as to your personal inheritance tax position, and they can also make recommendations to you about ways that you can reduce any inheritance tax. So, for example, they may discuss with you the annual gift allowance. So you can leave £3,000 in any one tax year to your beneficiaries without that having an impact on your inheritance tax position. They may talk to you about the exemptions for gifts on certain occasions, like marriages of your children, etc. Again, they may mention things like business property relief investments as a way of reducing your inheritance tax liability. Similarly, they may talk to you about what we call potentially exempt transfers. Potentially exempt transfers are essentially gifts. You can make gifts in any sum you like to your chosen beneficiaries. But if you do not survive them by 7 years, the value of those gifts may still be included in your estate when calculating any inheritance tax. After 3 years from the date of the gift, the amount of tax that's due is tapered off until you reach that year 7. But what tends to happen is the revenue will first take those gifts and use that to eat up any available inheritance tax allowances first and foremost, and then tax the remainder. So you'll often find that actually you can't apply the taper relief to the gift because it was below the original inheritance tax allowance. If you're making these types of gifts, it's important you get some advice because the dates and the order in which you make them can be very important. Another thing that they might discuss with you would be normal expenditure out of income. So the government says that if you're receiving an income that far exceeds your day-to-day needs, your general standard of living, whatever that may be, you may be quite frugal and not spend much, month to month, or you might live quite a lavish lifestyle and go on holiday very regularly. The government say that provided that you maintain that same standard of living, if you're receiving excess income, you can actually forward that on regularly to your chosen beneficiaries without it being included in your inheritance tax calculation. It may be that they want to discuss the use of lifetime trusts or care for annuities or similar planning, and also gifts to charity. On the note of gifts to charity, I will say, not just because we're doing this for Thames Hospice, of course, but generally speaking, I think a gift to charity is a great way to leave a legacy in your will. And what a lot of people don't realise is that where you have a taxable estate, if you gift 10% of what we call your baseline amount. Now, in really simple terms, your baseline amount is the value of your estate less your inheritance tax allowances. So what is left, 10% of that. If you gift that to charity, the taxable part of your estate actually benefits from a reduced rate of inheritance tax at 36% as opposed to 40%. And that might not sound like a lot, but we've got a little worked example here. So this is a real life scenario that I had with a client. The estate's value was worth 598,000. In the will, they had originally gifted a fixed sum of £10,000 to charity. So the chargeable estate was 263,000. The tax paid was £105,200, and that was at 40%, which meant that the beneficiary would have received £482,800. Instead, we did the maths for them and they decided that they were going to make use of this 10% gift to charity. And so the value of the estate remained the same, but the gift to charity was actually uplifted to £27,300. The chargeable estate came down to 245,700, which meant that a lower rate of tax was paid at 36% of 88,452. So you'll see at the end, the beneficiary received just, £552 less than what they would have giving £10,000 to charity, but they actually nearly tripled the gift to charity by making the most of this. So some people feel that it's a really great way to honour your memory by doing this. Most people will decide to leave their estates outright to each other, and that is perfectly fine. That happens in about 50% of the cases that I see. But when you leave your estate to your spouse outright, the estate then becomes theirs for them to do with as they wish. Now, it may be that they fall out with the children and they disinherit them. It may be that they just simply change their will. It could be that they enter into a new marriage later down the line, and that new marriage alone will revoke any will they have in place. It could be that they choose to leave their inheritance to their new spouse. In those situations, you can find that the beneficiaries of the first to die don't receive the inheritance that they were always expecting. So if you're worried about that, then there are different things that we can do in the will to make enough provision for your spouse, but also ring fence and protect your capital so that your children or chosen beneficiaries receive your share of the estate eventually. Now, I would say as well, one thing to note is that predatory marriages have been on the rise. And what I mean by a predatory marriage is that fraudsters have learnt that there's lots of ways to challenge a will. And it's very difficult to get a professional will drawn up if you are forcing or coercing an older or vulnerable person into making it. Instead, it's much, much easier for them to target vulnerable older people who may be having capacity issues and to essentially woo them and then under the radar, take them to a registry office, get married, and then they sit and wait until that person passes away. And on their death, they pop up saying, I was the spouse, the marriage revoked the will, and now under the intestacy rules, I receive the bulk of the estate. It's awful, it's terrible. So if you have concerns about your spouse perhaps becoming more vulnerable and susceptible to predatory marriages later in life, after you've passed, you may also want to consider putting in place a trust. There are lots of different types of trusts, and some of you may have had experience with them in the past. They range from being relatively simple all the way up to being very complex. I'm going to give you just a very brief overview of them. One of the simpler trusts that we tend to find is where we create a life interest trust for a spouse. And whilst you are not giving your spouse outright those assets because they're going in trust, the revenue will treat them as though they have been gifted outright. And what that means is they're spouse exempt on the first death, and you don't have to pay any inheritance tax. A life interest trust essentially makes provision for your surviving spouse for the remainder of their life. Quite commonly, what we see is that someone will put their half of their residential home into this trust so that their surviving spouse can continue living in the property rent-free. There may be funds available for them to use for repairs. It may allow them to downsize and invest any surplus and receive an income from it. But the capital that belongs to the trust is protected for the backstop beneficiaries, for the remaindermen, who often are children. This works very well in blended family situations where each spouse wants to look after each other, but also protect the interests of their separate children. It works very well if you're worried about those other influences on your surviving spouse after you've passed away. It doesn't have to only include the property, it can include investments as well. And it would mean that those investments, the income generated would be paid to your spouse, but the capital remains protected. Another form of trust that you might be familiar with is a discretionary trust. Now, where the life interest trusts are almost like a baby trust on the easy side of the scale, discretionary trusts sit much further along on the more complicated side of things. This is essentially where you put funds into a trust that will be managed at the absolute discretion of your chosen trustees. That means you have to trust them and that they can benefit the beneficiaries in any means they deem fit. A beneficiary does not have a right to benefit from the trust, they merely have a hope of benefiting. So your trustees could decide to pay all of the trust to one beneficiary, or they could divide it equally or unequally, or not make payments out of the trust as they may desire. These types of trusts have very complicated inheritance tax relationships. There could be entry, exit, and anniversary charges to inheritance tax. So generally, we only see them in limited circumstances these days, or I would only advise them in limited circumstances. That may be where you have very frivolous beneficiaries or beneficiaries that perhaps have either gambling or drug or alcohol problems, and you're worried that by giving them large sums of money that they're going to do themselves harm or that they're going to waste those funds very quickly. It could also be where you want to intergenerationally plan for a long period, because these trusts can run for up to 125 years, which means that whilst they have a complicated inheritance tax life themselves, you're not paying 40% on every generation change. It's spread out over a longer period, so can be more tax efficient. If you are thinking about these, definitely take professional advice and somebody ideally who is step qualified, so that they can talk you through the ramifications of this. Another one that people don't often know about is a disabled person's trust. Now, a disabled person's trust is essentially a discretionary trust with a primary beneficiary that is nominated. There is a long list of things that will qualify somebody as a disabled person under this legislation. I've given some examples on the screen there, so people receiving attendance allowance or DLA and PIP, things like that. If you want a full list, I can provide that to you separately. And it's a discretionary trust, so it sits outside that person's estate, and that means that it's not going to interfere with any means tested benefits that they may have, so it's not going to disrupt any of the services they may be receiving as a result of their disability. As long as the primary beneficiary is a disabled person, there will not be the usual entry, exit and anniversary charges to inheritance tax, so it simplifies them. But if the primary beneficiary passes away or isn't or no longer disabled, then the usual discretionary trust treatment will kick in. It's really important, therefore, obviously there's a lot to discuss and there are lots of complexities that are involved. So when you pick an advisor to prepare your will, it's really important you consider whether or not they're the appropriate person for your needs. Will writing is not actually a regulated activity, and there are some fantastic unregulated will writers out there, but there are also a lot of rogue or not very good will writers out there. Not to be regulated, it means that any one of you could go out tomorrow and start a will writing company. It doesn't necessarily mean you have the qualifications or the experience to be able to handle preparing those wills, certainly if there are complex elements. Solicitors are regulated, and I would suggest that you find a solicitor that specialises solely in wills and probate, like I have done, either a member of the Lifetime Lawyers or a member of STEP, because they are further qualifications specifically in this area of law. You may find that you will have an unregulated will writer telling you that a solicitor will be far more expensive. That's a narrative that they tend to put out there. Often that's not the case, because the will writer will get you in with very low original costs for your will, and then they'll start upselling you different trusts. They may even say things to you like, this will protect your home against care fees, this will mean that there's absolutely no inheritance tax to pay, etc., etc. And the issue with that is that if it sounds too good to be true, it usually is. There's always some kind of consideration there. So if you feel like you may have had an interaction with a will writer like that, I would suggest that you get it checked. And a key thing about this, I just wanted to mention, that often comes up, especially with those will writers, they'll say that if you put your home into trust, then you will absolutely avoid care fees on that. And that isn't always the case. Not only can putting your house into trust during your lifetime have implications from a potentially exempt transfer, or rather a gift with reservation of benefit perspective, which will mean that it will never sit outside of your estate for the inheritance tax purposes. It will always be clawed back in because you've retained a benefit, you've stayed living there. But also there are rules known as deliberate deprivation, and this means that if your sole reason behind your planning has been to deprive a local authority of assets for determining your responsibility for your care fees, then the local authority can take you to court and reverse any of that planning or transfers, so that they can essentially get their hands on that asset. It's known as deliberate deprivation. Very swiftly moving on to powers of attorney, there are two types. So whereas the will deals with things when you pass away and what's to happen there, the powers of attorney deal with what happens during your lifetime, but perhaps when you're unable to manage your own affairs. So they never cross over. One's for your life, ends on death, the other only comes into effect upon your death. So they're equally important documents. So yes, there's one for your finance and property, and there is one for your health and welfare. Before these documents can be used, they have to be registered with the Office of the Public Guardian. The finance power of attorney essentially allows people that you choose the right to be able to do things like buying and selling of your property, operating your bank account, claiming your benefits, paying bills, etc. on your behalf. This can be used while you still have mental capacity, because the courts see it that you have the capacity to keep an eye on things, and if an attorney is misbehaving, you can flag that up to them. The health and welfare power of attorney is slightly different because it can only be used when you do not have capacity to make decisions about your own medical treatment and welfare. So if you're unconscious or you're suffering from the advanced stages of dementia, for example. This power of attorney will allow your attorneys to deal with decisions like where you should live, what care you receive, and where you receive that care. It also gives them the right to refuse certain medical treatments if they feel that you would not have wanted it or it isn't in your best interest. And it can also, importantly, decide who gets to visit you and spend time with you. So if there are concerns, for example, like those predatory marriages, using the health and welfare power of attorney, they can actually limit the access that those fraudsters would have to someone who is vulnerable. In the health and welfare document, there is also a section about life-sustaining treatment. Now, life-sustaining treatment is any treatment which will not cure you, but it will prolong your life. So examples of this might be you being on a life support machine with very little chance of you ever recovering. But there can be more nuanced situations. For example, you might be living with the advanced stages of something like dementia, but living quite happily. And then the doctors say that you now have cancer, for example, and they may say that they can treat that cancer with chemo or radiotherapy or surgery. But it's not going to cure you, it's only going to prolong your life. Now, a lot of my clients in that situation feel that they would rather let nature take their course because of the overriding dementia diagnosis. So you can grant the power to your attorneys to refuse that cancer treatment and stick to your wishes. It's also important, I should say, that quite often without powers of attorney, if an elderly person has an accident and goes into hospital and there's an assessment done by the local authority, they often find that that person may have care needs that exceed what they think can be handled at home. And they would then have the authority to be able to place that person in a care home. If you have the health and welfare power of attorney, your attorneys can override that decision and ensure you receive that care at home. So your attorneys have to be over the age of 18. They have to have the mental capacity required to make decisions on your behalf, and they shouldn't have been made bankrupt either. Just from a practical perspective, I would also say that you shouldn't appoint attorneys who have criminal records, especially if it's something like fraud when you're appointing them for your finances, or people who are frivolous with their own money. Perhaps they might gamble, or if they have any addiction problems, they're not really suitable candidates to be an attorney. Your powers of attorney are incredibly powerful, and they give your attorneys the same rights you have to manage your own affairs. So you should appoint people who are trustworthy, and it doesn't have to be your family. It could be a close friend. Attorneys can act in a number of ways. You can appoint them jointly, which means they have to make all decisions together, but that can prove troublesome because if one of them is out of the country or unavailable, then the remaining attorneys cannot make decisions. More commonly, people will appoint them jointly and severally, which means they can make decisions together or separately. But you have to be okay with any one of your attorneys making a decision in those circumstances. Sometimes I get clients who will appoint their spouse in the first instance and then their children as replacement attorneys. But what they don't realise is that replacement attorneys can't act on a temporary basis, can only step in if the first named attorney is permanently unable to act. So if you and your spouse were in an accident, you are unlikely to get much better to manage your own affairs, but your spouse will make a recovery, even if they're unconscious now. Your replacement attorneys couldn't step in temporarily. So what I sometimes advise is that you name your spouse and your children together jointly and severally to add that flexibility. And here we've sort of mentioned about replacement attorneys, they can act in a similar way. It is possible for you to prepare powers of attorney yourselves. The forms seem very, very straightforward. And to be honest, the forms are. They seem that way because they are. However, the law surrounding lasting powers of attorney is not straightforward at all. And if you prepare them yourselves, the government will not give you any advice about the legality of them. The guidance notes on the Mental Capacity Act alone are almost 400 pages long. Okay, not many practitioners have read them, never mind lay people, they're very heavy going. So there's a lot of misunderstanding within the general public that the documents are simple because the forms are simple. And what happens is I've often had attorneys come to me now. There are about 60,000 cases under supervision at the Office of the Public Guardian because attorneys may have done something that they're actually not allowed to under the legislation, but they've done it in fairly good faith. It's, you know, for example, I had a client who gave up work so she could care for her parents full time, and they wanted to pay her a small allowance to make up for the fact that she was no longer getting her own income through work. And they had capacity to do so. But a few years later, when they lost capacity and mum had to go into hospital, it triggered an assessment by the local authority who found these payments, and they actually have removed her as an attorney because there was no provision for it in the powers of attorney, and she's facing financial and potential criminal action as a result. So, you know, as I said, whilst the documents are simple, the law surrounding them is not. If you are going to do them themselves, I would strongly advise you to visit a bespoke site that I have created, Power of Support, which has absolutely bundles of information about how to act as attorneys, what your rights are as donors, fact sheets and templates and all kinds of things on there. So go have a little explore there. If you do decide to appoint a professional to do your powers of attorney for you, examples where this would be appropriate, I would say, is where you want to pay your attorneys to act for you, where you or your attorneys want to make gifts using the powers of attorney, if you want to restrict the activities of the attorneys in any particular way, or where you have specific wishes as to how and when your replacement attorneys are to act. It is worth the time and the expense of seeing a professional to make sure that those wishes are properly given effect. So just so 32 minutes, just over, whistle-stop tour of wills and powers of attorney. My contact information I'll leave on the screen there. It is a lot of information that I've given you today, and I could probably do an entire session on any one of those slides. If there's anything in particular you would like to see from us in the future, just let us know. Or if you would like to book in with me to talk about your own specific circumstances, then we do offer a free initial consultation. There's no real time limit on that. Typically speaking, it lasts anywhere between half an hour and an hour, where we can go through your personal circumstances. If you have documents you would like me to review to check that everything's in order, we can do that for you too. But does anybody have any questions they'd like me to answer on anything they've seen?